Ms. McKenna?
Good morning. If it please the Court, Gail McKenna, Assistant District Attorney for the Commonwealth. This is the Commonwealth's appeal on a 211-3 petition.
Ms. McKenna, could you tell me, at one place you say there's a ruling, another place you say there's an indication. Did you go to the judge? Did you get a ruling?
Your Honor, we have a ruling. If I use the word indicated, I just mean that in the vernacular, the judge indicated that this is what he was going to do.
But an indication, you can't take...
He made a ruling, Your Honor.
And what's the ruling?
The ruling was that he was going to instruct himself on the law of threats. And he very clearly made this ruling. There was a charge conference. The judge said...
It's disputed.
Well...
Did you move for an expedited transcript? Did you get an agreement of facts? Did you go back to the judge and say, please give us a ruling?
But I would say that on page 8 of the defendant's brief, he concedes that the defendant actually made this ruling because he talks about what the judge said. So although he says that there's no ruling in the absence of a docket entry, and that is not our law or our practice that we need a docket entry in order to come forward on something. If that were our rule, then no instruction would ever be reviewed. Objections at trial would never be reviewed because they're part of the transcript. They're not docket entries.
Is there a transcript of the hearing on the charge conference?
There is not as yet, Your Honor. If there were, I would have...
Does it exist? I mean,
it will exist at some point in time.
Why didn't you move to expedite it?
I did order it, Your Honor.
Why didn't you move to expedite it? You wanted an expedited hearing. I've got to know what the judge said. I've got to have an agreement that this is what the judge said. I don't know what the judge said. The judge might have said, you know, one thing. He might have said another thing.
Well, I think it's clear in the record what the judge said because the judge specifically stayed his verdict waiting to see what the SJC was going to say.
The single justice stayed it.
Well, no, Your Honor. I'd refer you to page 5 of my appendix in which the docket sheet from the juvenile court is there, and the juvenile court judge stayed this until the court then ordered its stay. But the juvenile court judge himself, who had a copy of all of the Commonwealth's 211-3 filings and who actually made this ruling, entered a stay. He would not have done that had he not made a ruling.
Your Honor,
in fact, what he did...
One of the things that a trial judge often does is when the Commonwealth files and there's a hearing set, which no doubt you told the judge this is a bench trial, correct?
No, yes, it is, Your Honor. But we also had a lobby conference where I was present, the judge was present, his clerk,
was the lobby
opposing
conference
counsel.
Recorded?
No, Your Honor.
Don't we suggest that lobby conferences be recorded?
You do, Your Honor, and I think it's a good practice. This was not recorded.
Did you ask for a lobby conference to be recorded?
I didn't, Your Honor, but the clerk of the single justice of the SJC was also on the phone. I mean, this was...
On the phone with whom?
It was a conference call on the phone with the judge, myself, trial counsel, Mr. McElliott, the clerk was there, and a law clerk. And it was one of the clerks from the single justice.
It was a telephone hearing, wasn't it?
Yes, Your Honor, it was.
Which is fairly common.
And what was the telephone hearing about?
The telephone hearing was about how we were going to handle having the SJC hear, the single justice hear this matter, and what effect that would have on the trial and the status of the trial, and what the judge decided to do, because he wanted the advice of this court. What the judge decided to do...
He said that?
He did. It's right in the docket sheet. It's right there in the docket,
page 5.
He
said, I want the SJC to tell me how to instruct myself?
Essentially, Your Honor, let me turn to that page. I'll read it to you. He says...
Where are you?
Page 5, Your Honor, at the bottom.
Of
Ordered
what?
case taken under advisement pending decision of the SJC.
Yes, but that doesn't say he's asking for an instruction. I don't know what the ruling is, because he denied, did he not deny a motion for a directed verdict on the
Well, that's apples and oranges, Your Honor. You could find that the directed verdict would survive under either view of the law. However, we want a properly instructed judge.
And what do you want the judge to be instructed?
We want the judge to be instructed in accordance with the statute in front of him rather than the statute on threats.
Did you proffer a jury instruction and say this is what the law is?
We did, Your Honor. In fact, we submitted a memorandum in
Now, did you say this is what an instruction would look like?
What we did is we submitted a memorandum in which the Commonwealth's view of the law, same as presented to this court, was presented to the judge. I mean, there's no mystery here, and I think that you have to look at the way that the defendant's claim in this has sort of changed over time. In his original opposition to the 211.3, he said that it simply wasn't ripe until the metaphysical moment when the judge actually instructed himself.
Can I raise a little broader question with you that this case raises, and frankly, you haven't argued it, and neither has the defense.
Sure, Your Honor.
But it is an important one, and that is whether the Commonwealth should be coming up here under 211.3 in the middle of ongoing trials and asking for rulings about instructions, evidence, and so forth.
I think it's absolutely vital that this court allow the Commonwealth to do that.
Hear me out about this.
Absolutely.
The Vallata case says that you have the right to do that.
Right.
But it also says, and I quote now, where the issue raised by the Commonwealth does not concern a generally applicable interpretation of an important statutory provision. You don't do that here.
I think we do, Your Honor. I would contest that.
Or it may be addressed in the ordinary course of decisional law. That means we'll get a case sometime in the regular course of review.
But you won't,
The
Your Honor.
Commonwealth should not be disrupting the court, and relief should be summarily denied.
Well, let me step back just for a moment. Before we take a 211.3 petition to this court, we look at the law, and the law says that we have to bring something extraordinary where we have no other relief. And that was set forth in my memorandum. There's a co-defendant here who's being tried separately. This, if the court doesn't
Same
make a...
judge?
No, Your Honor, different court.
But trials are getting disrupted all over the place. I had 2 murder cases last month where right in the middle of them,
Right.
Commonwealth brings up this, the judges ruled against us on the evidence. Stop the trial. Halt the coming of the witnesses. And
Well,
I
Your
said,
Honor,
no.
because, Your Honor, we have no other recourse.
No.
And errors are made all the time
Well,
that
where was-
require the advice of this
You cannot
court.
come up on every error, correct?
And we don't, Your Honor. We're very careful about how we use the 211.3
No, I'm not asking as a matter
petition.
of practice or saying that your office or anybody else's abuses it, but
Right.
we have, I mean, the reason why, frankly, I was pushing you on a ruling is because it's, when somebody comes in and says the other side, for better or for worse, says the
Right.
judge hasn't even ruled, the first thing I would do if I was in your position is say, fine, let me get an expedited transcript. I'll show you what he said. I mean, now, I mean, 211.3s are extraordinary, and that it better be absolutely clear.
Right. And let me back up just a minute. The Commonwealth...
The judge said this in open court, not just...
Absolutely. In fact, Your Honor, what he did is he handed both sides a copy of the district court jury instruction on threats that's included in my record appendix. It was absolutely clear that this is how he intended to instruct himself.
When the defense attorney contested that no ruling was made, couldn't you have gone back to the judge and requested some sort of a supplement somehow to the proceeding so that you could have presented to us
Frankly, Your
the
Honor,
fact that he was actually ruling?
I thought it was completely clear from the docket sheet where he himself entered a stay, and from the fact that all of the documents were
Did
in
he
front
enter
of
the
him.
stay? It wasn't the single justice of the...
He entered a stay initially, and he said that he would keep the case under advisement and not decide it until the SJC had a chance to look at it, and then subsequently the single justice entered the stay.
I
So-
have to say, that doesn't seem to me to be an indication that he's decided that there was a ruling, because believe me, you know, when somebody's going up and the clerk of the single justice says, yes, we can get you on, and, you know, because presumably the clerk has conferred with the single
Sure.
justice, and the single justice says, I'm available, and the trial judge says, well, I don't know what they're going to do. I'm not going to make the arguments pro and con.
This was fully argued in front of the trial judge, Your Honor, and as I said, all of the documents were also presented to the trial judge, which we're not required to do, but as a courtesy, we did present them to the judge. And here, this very conscientious judge is concerned about instructing himself properly. And I think the issue is very significant, and the problem is that the Commonwealth will never get review of an issue like this unless we can use the 211.3 power.
It may well be this
because
is
what happens is you have...
Ms. McKenna,
I'm sorry, Your Honor.
This may well be you know, if it's clear what he thinks the law is. I don't know what he thinks the law is because I don't have a transcript.
Well, Your Honor, we can certainly expedite it, get it up to you as quickly as possible. It will say what I'm telling you that it says, and what the docket sheet tells you.
I thought, in response to a question from Justice Cowen, I thought you said that the lobby conference was not transcribed.
It wasn't, Your Honor, but there was a lengthy there was a lengthy argument about what the jury instruction should be in open court, in addition to the lobby conference. This is something that was thoroughly explored below, and I'm frankly at a loss to why the defendant is saying that he never made a ruling. And as I said, his claim in that regard has changed over time. He started by saying it was premature until the judge actually instructed himself. Well, that happens in this metaphysical way where the judge tells himself what to do, so there's no opportunity at that point, and his argument on appeal now is that there's no docket entry.
I take it, Ms. McKenna, that the nub of the issue is whether or not the slit has to be communicated to some person outside the conspirators. Am I correct?
No, there's two issues here. The first is whether or not a particular individual has to be targeted.
Right,
and as
right.
throughout the defendant's brief, he's asking the court to graft on this extra requirement of an intended victim.
Right.
And the statute quite clearly does not say anything about an intended
the victim could be the public at large, though.
Well, and that's why telling anybody who's a member of the public suffices.
Anyone outside of the conspiracy.
Why not within
Communicating
the
threat
conspiracy, Your Honor? There's no reason why anyone within a conspiracy is immunized and
Well, that's the
is
second
allowed to
claim.
keep the secrets.
That's the second point, right? So the first one
Correct.
is it's got to be communicated. Well, then it really is one. When I asked
Do we need a specific intended targeted victim?
No, no,
as we
when you
do
say
in the threat statute or the harassment
No,
statute.
wait a minute, Ms. McKenna. When you say communicated to
Okay.
somebody, it could be communicated not to a particular individual, namely Marshall or McKenna, but it could be communicated to the public. But that, and that's your second point, can't be the public in that sense for communication purposes. That's what I call the nub. Cannot include the co-conspirators.
Well, it should include the co-conspirators,
No, I understand
Your
your
Honor.
position, but I'm saying, is that the nub? And your
Yes.
understanding is that it is the judge's ruling.
Well, the judge gave
Wait.
it.
It is your understanding
Okay.
that it is the judge's ruling that if there is no communication beyond the co-conspirators, that he will find this defendant not guilty. Is that your understanding of how the judge is going to rule?
I don't know if the judge will find this defendant guilty or not guilty, either under the proper instruction or the improper instruction.
No, I understand that, but presumably, is there any evidence of any communication beyond the co-conspirators?
Yes, there is. There's evidence that the defendant and his co-defendant tried to recruit other individuals into this plan who
So in this
refused to
case,
join.
does it make a difference?
Yes, it does. It makes a very significant difference.
Because?
Well, because in any case like this, Your Honor, if we don't get the review of the court through 211.3...
No, I understand, but if there
let
were
me
no-
finish.
if there were no
But what
communication-
happens is that you have something that becomes essentially the law of the statute that's never reviewable. We don't have an appeal after a not guilty. And on appeal, we're addressing the issues that a defendant raises. The Commonwealth doesn't necessarily have the right to ask the court or to even to force the court to make decisions about things. They become hypothetical. We never
Well, and
get these
you
things
can't appeal
addressed.
after an acquittal. If he incorrectly instructs
Right.
himself and then there's an acquittal, that's the end of the day.
No, I understand that.
Absolutely, but even beyond that, even on a defendant's appeal, the Commonwealth's issues don't necessarily get addressed. So if we came before the court and said, look, this instruction's wrong, the court won't necessarily address that because the court is looking at things from the defendant's
But
perspective.
aren't you saying then on any ruling of any sort made below where you don't have a specific statutory right to appeal, and you do on some, there's no remedy and therefore it's a matter of
No, Your Honor.
substantial importance that this court should hear it?
No, Your Honor. What I'm saying is that the statute says that the court shall have the jurisdiction to look at these types of cases, and the court has many cases in which it said you need two things: no other remedy in exceptional circumstances. And so we, the Commonwealth, take that very seriously, and we wait until a case in which there's exceptional circumstances.
What kinds of things fall into the category of exceptional circumstances?
Well, we had a case the other day we weren't able to bring up, but we had a judge, jeopardy attached, and he allowed a motion to suppress in the middle of a trial. All our evidence was gone. I mean,
Motions to
that's
suppress are appealable. You have the right
not
to do
after jeopardy has attached, Your Honor, and he does it as a matter of of something that happens in a trial. We have no appeal. We have no resort.
Was this a
You're
jury
talking about an
waive?
evidentiary ruling? He's not allowed you to ask the witness a question or not allowed a document in? You
No,
think you should just
he's
bring those right
excluded
up to
all
us?
of our evidence in the guise of a motion in limine, which
So
is
that
in
the-
essence a motion to suppress on typical motion to suppress grounds.
And you're saying you cannot appeal that?
Absolutely not.
Couldn't you have sought,
Jeopardy has
couldn't
attached.
you have sought a stay of the proceeding, and if he refused to grant it, come up to the single justice and sought a stay of the trial on the basis that jeopardy had attached, and you couldn't retry, and that you need a ruling on the motion to suppress?
Your Honor, this backs up the fact that we're not picking on individual cases. What we're trying to do is find issues that are reoccurring or that might reoccur that create exceptional circumstances. That's just one example, but no.
Ms. McKenna, can I just go back to, is there something in the district court's model instructions to which the Commonwealth takes exception?
Yes, Your Honor. It's reproduced in my brief, and the district court's instruction specifically says that you have to have an intended victim and that the communication had to be intended to get to the intended victim
On this statute,
under the threat
the
statute.
general threat statute.
The general
But the
threat
problem is that the
statute.
judge was going to instruct himself on the general threat statute, not on the statute under which you had brought the case.
Absolutely. Our statute
the whole
doesn't
problem.
require an intended victim.
I have a question about the second question. You
Sure.
ask what manner of communication is necessary under 14B. Are you asking there for an advisory opinion?
No, I'm asking for the court simply to say that it doesn't have to be the type of communication that you look at under the general threat statute, which is what the judge has said that he
In
would
other words, it's
instruct
just a
himself
different way
under.
of phrasing your first question.
Yeah, I think you could look at it that way. It is a different way of phrasing my first question, but it's a little more honed in on
Well, that's
the
why you were
issue.
confusing me when you said there were two. 'Cause
Well, I never mean to confuse the court, so I
No.
apologize.
Speaking for myself, Ms. McKenna, it would be extremely helpful if you could get an expedited transcript of whatever,
Happy to do so.
and also if you would let us know how soon you can get that, because, I don't know how soon you can get an expedited
I will
transcript.
find out this afternoon.
And I take it that it doesn't have to be the whole trial. It's whatever. You said there was a lobby conference, then there was a recorded.
There was a lengthy charge conference in open court, which was fully recorded.
Okay, that would be extremely helpful. Thank you, Ms. McKenna.
Thank you all for your kind attention today.
Mr. McGilligott?
William McElligott, ladies and gentlemen, for Tobin Kerns. I was a trial counsel on this case. Judges, this involves an incident which occurred on October 22nd, 2004, allegedly, when he was indicted for basically 3 charges: promotion of anarchy, conspiracy, and threats to use dangerous weapons, 269, Section 14B. He was charged as a youthful offender under the statute. The trial began on October 16th, 2006, and I was the trial counsel on this case, and it lasted a week. After the hearing, after the trial, after the evidence from the Commonwealth, I presented 3 motions for directed verdicts. One was on the anarchy charge, which was allowed. One was on the conspiracy, which was denied. And one was on the threats to use deadly weapons, which was also denied. My position is, and Mr. Kerns is, that the petition for relief under 211.3 is improper because there's really no ruling that the court has to go against or even...
Does the judge's denial of your motion for required finding on the third charge, the threats charge, indicate that he was going to proceed under the 14B statute, Chapter 269, Section 14B? Since if he were going the way the Commonwealth suggests, wouldn't he have allowed your motion at least in part?
I would agree, but he did not. He denied the motion. So our feeling is that there's no real appealable issue here because there's nothing to appeal. And if you look at the list...
Mr. McGilligott, let me ask you the same question. Did you go back in... Did you participate in this telephone conference call with the single justice clerk?
In fact, what happened, Judge,
What's
is...
the answer to that, yes or no?
Yes, I did.
Okay, so you know there's an issue. You know there is an issue. You're raising it as to whether or not there's a ruling. Can you not go in and say to the judge, could you please, in a sense, it's as if you either get a written instruction if there's no jury, which is a little odd, but if you think the judge is interested in getting guidance because the judge is going to go that way, which seems to be inconsistent with what the Commonwealth is saying the law is.
Can I explain? What happened was the judge recognized that there was the word threat in the statute. So what he did was he looked at the usual threats language in different cases, and he cited the Maiden case and he cited the Troy case. And basically he said that he thought, in terms of threats, there has to be either some kind of an intent to communicate a threat someplace. Basically, that's what, if I boil it all down, that's what he said. And I think that's an extremely important element in the charge that Mr. Kerns is accused of.
Did you make that argument during the hearing on the motion for required finding?
When I did the motion for required finding, Judge...
Did you make that particular argument?
Yes, I did, Judge. Basically, what I said was, under this particular statute we have here, you have to have some communication. Because if you take a look at the statute as a whole, it goes on to talk about costs, it goes on to talk about things only to deal with communication. It talks about restitution, and most importantly, it talks about the person who's being communicated to experiences anxiety, he experiences personal discomfort, and that's part of the statute.
Did the judge give his reasons as to why he denied the motion for required finding of not guilty? Or did he just deny it?
Well, again, he looked at the threats language in other cases. He looked at that. In fact, he even gave us a blurb on it. And basically, he said that, in his opinion, that if you take in the light most favorable to the Commonwealth, really, there's no real he just couldn't go along with it.
Now, I know you didn't come here to get involved in 211.3 practice, but the single justice denied this petition. Might it not be affirmed on the basis that, yes, technically speaking, the Commonwealth has the right to come up on these matters like evidence and instructions and disrupt to some extent an ongoing trial? But so the single justice looks at it and says, well, yes, they can come here. But this is so muddled and not of such a significant issue that as a matter of discretion, I refuse to entertain it on its merits, denying. Wouldn't that be enough?
I would think
and we would uphold him, and there, if we write such an opinion, we could put a limit on some of these things?
I think that's an excellent idea.
But then the Commonwealth can appeal under Rule. The Commonwealth can then appeal under Rule 221, though, can't it?
It's already appealed under 221.
It already
and
has
that's what
appealed
we're
under
here
221.
Okay.
Yeah, but I
That's
started
how
by
God does, I
saying
understand.
I started by saying the ruling, the single justice could be affirmed simply on that basis, without getting into this entanglement of should the judge, was there a ruling, or what statute applies. Just simply 2 or 3 sentences saying what I just said.
I would agree, Your Honor.
But then if assume there was a ruling, because we're going to get a transcript, so we'll know that shortly, we hope. And let's assume there was a ruling. And if his ruling is incorrect, and if we go the route that Justice Graney just suggested, then if the judge has incorrectly instructed himself, or does incorrectly instruct himself, and acquits the defendant, because it's jury waived, then the Commonwealth is left with no remedy. And there may well have been an error, a significant error of law.
I would tend to agree with that, Your Honor.
So that
I would
by
tend to agree with
denying,
that.
so that it may well be an abuse of discretion in this case, because if we believe that there's an error in the way he's instructing himself, we would need to.
No, it would
There
be an
wouldn't
abuse of
be.
discretion over the single justice.
Right, I understand, abuse of discretion, because the single justice would have denied the Commonwealth any opportunity to remedy an error.
211.3 is supposed to be for extraordinary matters, and this does not appear to be one of them.
I would agree, Judge.
Mr. McGillicott, and maybe I should have asked Ms. McKenna this. Well, I actually have another question for you. When you filed your motion for the directed verdict,
Yes, Judge.
I take it that part of your argument was there's no evidence here of an intent to communicate a threat to anyone, correct?
That's correct, Judge. I also argued that not only was there no intent, but nobody outside the alleged conspiratorial group
Right.
was ever felt threatened, ever felt
Right.
had anxiety or anything like that, which the statute talks about.
And I take it that the Commonwealth said, under 16b, don't need that.
Exactly. The Commonwealth basically says, as I understand it, and that what they argued is, You don't need it. All you need is, I could be in my living room and say to somebody else, I'm going to blow up the school, and no one else hears it. That's enough.
Okay. If that was the Commonwealth's position, and if the judge denied, this is Justice Cowen's question, but I just want to be specific as to what the argument is. If the judge denied your motion, doesn't that mean that the judge has not accepted your interpretation of the statute?
I would say perhaps yes.
Back
say
to the
perhaps
abuse
yes.
of discretion. Did the single justice give a reason for his ruling?
I don't believe so, Your Honor.
So then how can we tell whether he abused his discretion when we don't know the basis for his ruling? It could have been any number of things. It could have been that there's no ruling in the record. Could have been that this isn't important enough for 211(3) relief. Could have been blah, 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 blah. So how can we go the way that Justice Graney suggests, say that there was no abuse of discretion when we don't know the basis for the ruling?
That's a good point. I just assumed that the reason it was not granted was because there was no real basis for it, because there was no ruling in the lower court.
But we don't know that. He didn't write another
Could we
sentence
send it
saying-
back to the single justice and have him make
Oh, please.
rulings?
I would have no problem with that as well.
Did the trial court judge, well, let me start again. Did you request a hearing, a finding on a lesser included offense of threat to commit the crime, the general threats to commit a crime statute? Or did the judge indicate he was considering a lesser included offense? He would consider a lesser included offense under the general threat statute?
No, the judge did not say he was going to consider a lesser included offense. What the judge said is, we have a statute which was enacted, I think, in 2002, and it has the word threat in it, right at the very, essence of the statute. And he said to himself, okay, this is what my interpretation is. I'm going to look to other cases that interpret what a threat is and then apply it to this case, essentially.
So did the judge indicate that he was going to instruct himself that a threat would be the present ability to carry out a particular crime against a particular person?
Judge, I think he was more interested in the element of communication. And what does communication mean? Does it mean just among the conspirators? Is that what communication means in the statute? Or does it have to go beyond that? He was focusing on that. And he was also focusing on intent. What is involved in the intent with the threat statute?
Mr. McGillicott, do you agree with the representation, and I don't mean to suggest that there's anything wrong with it, that unlike the hypothetical that you gave me, which is, you say to somebody in your living room, I'm going to blow up the school, that here there was evidence that this defendant had communicated outside the group of co-conspirators?
I would say that it was not credible evidence, but I would say there was some evidence in the court that he allegedly did have people. Yeah,
Isn't that a reason? Because I took that to be the import of Ms. McKenna's answer to my question, which is if there is an acquittal, or even if there's a conviction, let's take the conviction part because then the case would come up here. We don't know whether it was because the judge didn't find that evidence, did find that evidence credible, or whether the judge was instructing himself correctly on the law. Are you with me? And if there's an acquittal, the Commonwealth doesn't know whether it's because he did not accept your argument that it has to go outside, but that he didn't find the evidence of the outside credible.
Judge, I think we're kind of projecting what's going to happen in this case because, as you're probably aware, Judge Coffin has reserved everything in terms of the actual verdict. When he gives a verdict, I certainly have confidence that he will explain exactly why he gave the verdict and exactly what he considered.
Have you had other jury waive trials?
Yes, I have, Judge.
Do judges normally explain the verdict?
I know Judge Coffin does, explains it in great detail.
But that's not required. You don't have to. You can just
I
say
know.
let the jury.
He's a very thorough judge, Your Honor.
Yeah, in fact, isn't this the best time to find out how he's going to instruct himself? Because he should have made rulings on requests for instructions. He should have said, I'm going to allow this or I'm going to deny this particular request for an instruction.
Well, I keep coming back to the fact that he wasn't focused. He was focused on the word threat in the statute. He didn't come out and say the Commonwealth's version is wrong necessarily. He didn't say that. He just was concentrating on that word threats. What does that actually mean? And he went to the law on threats in the Commonwealth, and he
Did
cited...
you have a hearing before the single justice?
Yes.
A hearing?
We had a hearing on immunity before the single justice, which is a separate issue.
No. On this, did you have a hearing on this 211-3?
No, we didn't.
Okay, well, I don't understand why nobody went back to the judge and didn't ask for some clarification here when it became, I mean, your position was that he never made this ruling. You didn't ask him to clarify.
In fact, he hasn't made any ruling.
That's right. That's exactly the point I'm trying to make. He has not made a ruling. Therefore, I think that
Well, we don't know that. The Commonwealth says he has.
Let me take it this way. Whether or not there's a ruling, I'm looking at the Commonwealth's brief, right? Because she did rather go between indication and ruling, which is a little different. But let's assume he had indicated, right, that he was going to go with district court jury instruction on threats. Okay? Do you agree that the judge indicated that he was going to go with a district court jury instruction on threats?
You have to separate threats from the entire statute, Judge, because the statute goes on and on and on.
No, I understand that. But do you agree that with respect to the threat piece, because I'm looking at the instruction, it says first, the defendant communicated to, and then it says alleged victim. Alleged victim is not co-conspirator. So right there, I think, I'm not asking Ms. McKenna to communicate non-verbally, but it seemed to me that if that's part of what he says, that's how I'm going to look at threat under 14b, at least if there's agreement that that's what he's doing, one could look at that, correct?
Certainly. He did, like I said, indicate what the law was, he thought, on threats, and he did cite cases, and he did give us a blurb on it. My sister's correct in that. But he also...
What do you mean by a blurb?
Well, he gave us, like, cases, which is attached to her brief, actually. He gave us,
Right.
you know, like he cited
And
the
that's
Troy
in the
case, the Maiden
recorded,
case.
that's from the bench in a recorded session. That's not the lobby conference.
That's correct.
Thank you, Mr. McGillicuddy.
You're welcome.
Ms. McKenna, before you go, one of my problems I had was your brief, the Xerox is so bad, I can't read what happened in the...
I understand, Your Honor. That's the way
So-
I got it from the juvenile court. I'll get a new...
Could you do
Yes,
that?
and-
Because
and
when
could
it
I
comes
ask-
to dates, figuring out who was doing what where...
Could I ask the Court's permission to brief the 211-3 issue, which was raised for the first time here at oral argument, in the kind of depth and importance that the Court is putting on the issue? I would appreciate the opportunity to submit a supplemental
I
brief.
hope so, because I have grave reservations about what's going on.
I know you do, Your Honor, and I think that if we can address that, and address that perhaps by looking at some of the other DA's offices and fully brief the issue, it might be helpful to the Court.
Certainly, Ms. McKenna, and may I
Thank you.
suggest that Mr. McGillicuddy can do the same thing, and it would be most helpful to the Court if you could work out a briefing schedule so that he can look at what you have to say and respond to it.
Oh, absolutely.
And fit it all with, I don't want to delay this thing endlessly, and figure out how quickly you can get the transcript. If it's a month, maybe you can work on a 14-day back and forth. I mean, the case law is not extensive under 211-3, so, and most of the cases, the critical cases, are already in your brief.
No, and, you know, my belief was that I had to come up on whatever was in front of the single justice, which is why I didn't go ahead and do a supplement, but I'm more than happy to
No, that's fine.
whatever it
Admittedly,
needs.
This issue has kind of popped up because this whole debate over ruling, no ruling, sort of brings it a little bit more into focus. So sure, go ahead and brief it, and he can brief it, and I assume you'll get briefs from CPCS and the Criminal Defense Bar.
Sure. Thank you very much.
Thank you all
Thank
very
you.
much for your attention.